Mention. Mention. Mr. Banerjee, we have some mention matters. Let
Yes,
us complete those mention matters. We'll take up your matter
Lordship.
for five or 10 minutes.
Lordship. Lordship.
Yes.
What's my to mention item number 38, 39, 40 of
38, 39.
38, 39, 40 of this is a matter pertaining to an ED case where we have the accused has been discharged. I had made a mention in the today, but the person who was signed, he was not. So I just made a recommendation till
He got already the discharge order.
in the PDA case, the predicate offense, there is a discharge. So
Okay.
that will be brought on record and the there. So the ED case of this. Will you take some the type?
I'm appearing for the respondents.
You're for the enforcement.
Enforcement.
Enforcement. With the consent of the other side, it is the enforcement department. The learned counsel for the petitioners. A good item. So that's great. Here in one matter, Mr. Ken Chaudhary was there.
In all the matters.
In all the matters. No, I is filed by RKD
I
Chaudhary.
It's filed by the department.
I'm Mohan, the learned counsel for the petition. Matter is adjourned. Yes, any probable date you want now? 16th of June. All list accordingly, all the matters on 16th. Okay, we're listing all the matters on 16th of June. Brought on record if there is any discharge order. Brought on record if there is any discharge order and all.
Deeply applied.
Wait, is the lordship? So I beg to mention item number 16, lordship.
13.
16.
13.
16, lordship.
Sorry, 16.
16, lordship. 16.
Yes, 16. Huh?
Lordship, there is difficulty on the part of senior counsel, lordship. This matter may be adjourned. Lordship, I have already taken the consent from the petitioner counsel, lordship.
Otherwise, you are for the respondent.
I am referred to respond number 3. Yes, lordship. Can the matter fix on 11th of June, lordship?
With the consent of the other side, the learned counsel appearing. Your good name?
M. Nirola, lordship.
M. Nirola appearing. You're for Mr. PJ Sekia.
Yes, lordship.
Appearing on behalf of Mr. PJ Sekia, the learned senior advocate. Wait for an adjournment. Prayer allowed. Lizzie, you want to fix it on 11th of June?
11th of
June. Okay, then 11th of.
Hello, there was an interim order that to be continued.
Interim was there.
11/6
going to interim order be continued till next day.
Lordship, in this matter, this matter may kindly tagged with WPC number 4497 because the similar issue.
4444.
WPC number 4497 of 2025, Lordship.
WP criminal or what?
No, WPC civil, Lordship.
Civil.
Because here the challenge the jurisdiction of the authority, Lordship, out of the same FIR, Lordship.
Okay, then WPC 4496/2025.
97, Lordship.
Sorry, 97/2025.
Yes, Lord.
Please the matter accordingly along with WPC 4497.
Yes, Lordship. Obliged.
Then I paid it. The order, the you're supposed to
Mr. Borwa is suggesting that it may be listed on 18th otherwise, 18th of month. Okay, we'll do it.
May I please, Lordship? I beg to mention item number 51 of daily list for adjournment. Lordship, due to some medical emergency of the engaged counsel could not conduct the matter today. Lordship, kindly adjournment the matter for 2 weeks. I am for appellant. I'm
You are for
appearing
the
on,
appellant.
yes, Lordship. I'm appearing on behalf of MS N. Hassan.
And Hassan.
N. Hassan.
No, but appellant, you have filed one I think. You are not for the appellant. Mr. U. Chaudhary, legal aid counsel is, acha, oh, that is a difference, acha, anyway. Okay, you are for the appellant. With the consent of the other side, the learned counsel appearing on behalf of Mr. MS N. Hassan, paid for an adjournment, prayer allowed, estimate accordingly. It will be listed after 2 weeks as on a date to be fixed by the registrar.
Problems.
I beg to mention item number 14.
1-4.
1-4, yes. Your sir, Madam, it kindly be adjourned for today. As my signature is
You are for the petitioner.
Yes.
Same order prohibited, stating that the learned and this counsel is out of station. You want any fixed date here? You want any fixed date here?
Next week,
Next week is not possible. 3rd of June.
okay.
May I please, Your Lordship, I beg to mention item number 22. City was called for.
Yes, what
It
is
is
the
not a-
position of 22?
Yes, do I not receive, Lordship?
Are you on interim?
Yes. So, in time, Lordship.
CD not received. Issue reminder. Yes, when it can be.
Arrange that in a month of 3rd.
3rd of June. 3rd of June, interim be continued till next date of listing.
Like this. Can be shared.
52 is scan copy you have received.
Can copy received.
Who is not there? Mr. Sarkar.
He's out of station.
Adjournment already put it. Scan copy of the TCR has already been received. Passover for today. The matter may be passable for today. The registry will fix it as the matter may be fixed as an edit to fix by the registry.
May I please, Your Lordship? Lordship, I beg to mention item number 37. Lordship, Path's CD is not available, Lordship. And I am not interim, Lordship.
Case they not received, Lordship.
Not available.
Not received.
You are not on interim.
Not. Next week, they needed me.
Let us report.
Obliged.
Issue remain 26. Oh, 26.
Initial charge sheet submitted.
This charge is submitted. We cannot give you such a long date. At best, we can fix it on Tuesday. Now, see, you just talk to your counsel. A simple case. Are they on interim?
Yes.
Yes.
So you are on interim. We are just extending your interim up to 15 days. And in that case, we'll be liberty to approach the learned trial court below. But however, I'm not passing any order because you may not be in a position to say anything. So you just talk to your counsel so that we can fix it on either Tuesday or Wednesday. Will be okay for you? Or no? Mother died. Achha.
So it's always been 3 days.
Pardon?
For the Hindu day to perform on that.
Goswami, can it be after 1 week then? First, as on a date to be
Lordship.
after 1 week, as on a date to be fixed by the ministry. Interim be extended till next date of listing. We are extending your interim. Item number? Huh? Item number 31, we have already received this scan copy. 1-3. Yes, what is the position of 1-3? Here we TCR has been received now. So you are for the petitioner or for the respondent? Have you taken consent of the other side? MSS Nazdin is letting amicus for the sole. Okay, you talk to her, huh? Just inform her. Okay, adjournment right. After 2 weeks as an edit.
But I recommend, I think, by 18 or the CD was called for. It is not.
We have not received the case dry, Lordship.
You are on interim,
I don't think.
city not received, issue reminder. Yes, when it can be fixed.
Lordship, it is,
Let it be 4th of June.
as per the Jackson,
4th of June. But-
It's good.
Age 4 days. No, whatever. We are
Lord,
fixing it on 4th of June. Interim be continued till next date. MS Nazdin, you are here for sole respondent, I think, na?
Yes, sir. Yes, sir, Lord.
So she's praying for adjournment, so we are listing it after 2 weeks.
Of leisure, Lord.
Lordship, can you take me?
Date 2, in that case, it will be go up to month of June, not 2 weeks. 16th of June.
June. Of leisure, Lord.
What do you call it?
Yes, Mr. Banerjee. Yes, you can start.
Lordship. Lordship, I'm appearing on behalf of Shamkanu Mohanto. The matter is nidificated by the prosecution on the basis of circumstantial
So we are
evidences,
just
though
increasing the volume,
circum-
Mr. Banerjee. Right. Yes, we are increasing, just increasing the volume in fact.
Lordship, I am incarcerated for 227 days. The prosecution
How many
has
days? Two?
nidificated the case 227 days.
Acha.
As of
Okay.
now, 227 days. So prosecution has nidificated the case on the basis of circumstantial evidences, though the circumstances are not connected to each other. There is a gap between the circumstances. So they are not linked properly. On the basis of that case, I am being taken. I have cooperated with the investigating agency. They sent me the email correspondence when I was in abroad. My bank account was being freezed and I could not, it was not possible from my end to come back to Kolkata, come back to India. And there, when I tried to come back to Gauhati, I initially apprehended in New Delhi airport. From there, I accompanied the SIT to Gauhati, and there I was been cited as imprisoned. Since then, the investigation roved around some surmised and conjectured fact. The statement of the co-accused, which is not been corroborated, those have been relied upon to nidificate the case. Charge sheet has been submitted. I have been there incarcerated for a long period of time, and there during these 227 days, I have applied for different for supply of relied upon and non relied upon documents, and there it is pertinent to mention here that I had ventilated my affliction that during the investigation, nothing has been transpired against me. Only the allegation that I have given the alcohol, but neither the bottle of alcohol is recovered, nor it has been corroborated that I have given the alcohol. Rather, there is a mail which is not being incorporated in the investigation charge sheet that I had circulated one mail that alcohol should not be served upon the deceased person. So I was not on the proximate proximity of the incident. Whatever the incident has caused the death, now it is subject to whether it is accidental or it's motivated. but I was not under the proximity of that incident. I was not in the yacht party, nor there is any document to show that I have been hatched up any conspiracy for commission of this crime. There is no mainstream of proof, nothing was there. In spite of that, I am incarcerated for 227 days. Your Honor,
Okay, yes, just a second, Mr. Banerjee. Yes, what I'm submitting that today we don't have anything before us.
Lordship.
I think before hearing the matter further, better, yes, Mr.
My
Saikia.
submission is very clear. Whatever he is submitting, that is one side of the story. The other side of the story is well enumerated in our case diary. So if the case diary is called for, Lordship will see there are overwhelming materials against the person who has filed this bail application. It is he was a part of a conspiracy. He did not have to be present at the site of the incident. He has game planned everything in such a way that ultimately the heartthrob of the state had to give up his life. It was well designed, and he has emotionally blackmailed and took him to Singapore. Number one, he has conspired with some other persons, part of that conspiracy, and made a situation from which it is very difficult to come out. Number three, he is well aware of the health condition of Jubin Garg. In spite of that situation, where he is well aware that Jubin Garg should not be taken to any place which is near water or to the water, and also from fire. All these things were known to him. He is well aware. And after that, he also knew that Jubin Garg is terribly unwell. He should not be allowed to take alcohol, and he was ensuring that there is constant supply of alcohol through another person. They are all accused persons. So my humble submission today would be, the matter is going on at the stage of discharge. The discharge order will be passed on 26th. And thereafter, Lordship may take up the matter, will produce the case diary, maybe in the first week of June. Let the notice be issued at this stage today. And without looking at it, will be not feasible for me to also argue, and Lordship will also not be able to know what are the materials present in the case diary on the basis of which the discharge argument is going on for last about 20 days. More than that. Now, the discharge argument is over. The date is fixed for the delivery of judgment on 26th of May.
Lordship, 26 would be too far.
If suppose, if the person is discharged, then this petition will become redundant.
But
So
if
let
the
us wait
person
for
is-
that day.
If the person is enlarged on bail, that would not create any impediment for the trial. Because discharge has nothing to do with the bail application. If I succeed the bail, I would continue with the trial. If the bail petition application is rejected, the charge will be framed. I would be in custody.
Yes, Mr. Saikia, obviously the order is fixed on 26th of May. So I think it will be a bit longer date, I think, for case diary.
If Lordship wants to take it before that, because I am told that the case diary is also with the Honorable Court.
Honorable Court means here only.
Trial court.
Trial with trial.
Because the court
So
is
I was told that it is a very voluminous
very,
one.
very.
A very voluminous one. So kindly just relevant copies can be flagged it off by the relevant
we
copy,
have
then
to
it will
take
be
the-
easier for the court also.
Absolutely, Lordship will do that. And if Lordship is pleased to fix the matter before 26, also we are ready. We will be ready by that time. Today is, I think, today is 14. Today is 15.
Today is,
So around 23rd, 24th, maybe taken up.
it'll be okay, Mr.
Lordship,
Banerjee, 23rd or 24th?
Lordship,
23rd,
can it be done
24th.
on 20 or
Pardon?
21?
23rd, 24th.
Yes,
Because,
23rd or 24th?
Mala, it's a holiday, madam.
Oh, it's a holiday.
Lordship, even
Sorry.
that case also
Let
it
it
will
be
too
on
long.
22nd.
Oh, in
Friday.
that case, it will be on
Lordship, it would be
22nd.
too long. Lordship, it would be too long, I presume.
22nd is the
That's
today is
very nice,
20
Lordship. Then we will also have to go through the case diary.
Yes.
I am not privy to the case diary at this stage. I have to bring and
We
I
have to go through the case diary for your submission. We
Yes.
are the
and we have to find out the excerpts from that case diary to be
Hmm.
presented to the Honorable Court. So that is a reasonable time. Normally, Lordship is 2 weeks to 3 weeks time. Here we are only saying that 1 week now.
yes. The 22nd will be, I think, it will be.
Lordship, I have another, I'm craving for submission of another supplementary affidavit. as some of the document which I have been tendered before the court below was not been annexed here, and some typographical error is also there in the bail application. So for rectification of that, if the Lordship allows me to submit a supplementary affidavit.
For rectification of your bail application or
No,
for
no, no.
any papers
No,
and
for
all what?
tendering some papers and documents which is very relevant for adjudication of this bail application.
So those documents which were applied for, you have already received those documents or yet to be received?
No, it is with
The documents we
us,
have, yes.
but that has not been annexed with the bail application. So tendering those documents, I am praying before the Lordship to submit a supplementary affidavit.
I am raising no objection, but we have to give a response to those documents also. These are not part of the
Definitely, I will
record.
serve the copy. Definitely, I
We'll
will
have to
serve
give
the
a
copy.
response to that. For that, we'll have to file a affidavit maybe. If the additional affidavit and
that
additional
case-
documents are brought into record. Lordship cannot take any documents on face value.
Obviously.
No. I would definitely serve the copy. I would definitely serve the copy within next Monday to the prosecution before submitting it before the honorable court.
Okay, then that can be done. Okay.
In that
Lordship.
case, Lordship may take up the matter on Wednesday. Let us go through it, whether we'd like to file a response or not. Or otherwise, Lordship may extend one more week after 22nd so that we can file a response. Today, that order can be passed also. If they want to file
Lordship.
additional documents by Monday or Tuesday, I am not objecting to that. But to that effect, I have to file a response because these documents we do not know. These are not part of the case diary or
Lordship,
part of the records before the trial court also, if I'm not wrong. So these
Lordship,
are very... Otherwise, I am ready for 22nd in the present form of the bail application. If they want to modify or bring additional documents, I would need 2 weeks time.
Lordship, this is not the new documents. Rather, it was been introduced during that bail application moved before the trial court, and the application and some of the documents are part of charge sheet. So some of the documents are part of charge sheet, and some of the documents would have been already placed before the bail application when it was moved
You'll do
before the
one
trial
thing
court.
then. You furnish the copy of your additional affidavit to the other side. You
Lordship.
peruse this one, and if you think that on 22nd that may be heard, on 22nd, if you think that you need another 1 week or 2 weeks,
Lordship.
that we'll see. But
Lordship.
if it is
Lordship.
not that type of document, then we can hear the matter.
Lordship. No
Okay.
difficulty.
Lordship. Lordship.
I heard Mr. R. Banerjee, the learned counsel for the petition, and also heard Mr. D. Saikia, the learned. You are appearing under its Wistang and additional
As an advocate general.
as an AG, and also heard your Mr. Jet Kamar,
Assisted by PM Chaudhary.
the learned senior counsel, assisted by Mr. Jet Kamar. Oh, sorry, Mr. BM Chaudhary, the learned counsel for the respondents. Sorry, yes, Mr. Medhi, you are for the informant. Also heard Mr. W.R. Medhi, the learned counsel appearing for the informant.
W.R. Medhi and Peter.
P. Talukdar. Okay, then P. Talukdar. This is an application under section so and so in connection with so and so. It is submitted by Mr. Banerjee that the present accused petitioner is in custody since class 227, and he is not at all linked with the alleged offense, and he is basically arrested only on suspicion. Nothing has been nothing, no evidence has been brought there against the present petition, nor there is any evidence of evidence that he supplied the alcohol to the deceased. Full stop. He all along cooperated in the investigation of this case, and considering this his length of detention, he may be released on bail. Next para, Mr. Saikia, the learned AG, submitted in this regard that he is the one of the person who is the part of the conspiracy, and the entire of crime is well organized, wherein the heartthrob of Assam, this is Jubin Garg, was uh, was supplied with not only alcohol, but he was also brought near to the water, which was being aware that he is not allowed to go near to the water or fire, and the health condition of this is Jubin Garg. In review, Mr. Sakya also submitted that the uh, case diary and scan copy of the TCR and the case diary will be required to go for the further hearing. Next para, considering the submission made by learning counsel for both, this court also feels that the relevant documents connected with the present accused petitioner will be required for the disposal of the case diary. The bail application. Next para, Mr. Banerjee, the learned counsel for the petitioner, further submitted that he have already tendered some documents, and some corrections in the bail application is also required, and hence he may be allowed to submit one additional affidavit to that. However, he submitted that a copy of the additional affidavit will be provided, served to the learned AG within Monday. Within Monday, you are going to, or within Monday or Tuesday? You're going to submit your copy of the additional affidavit to the other side by Monday or by?
I would submit by Monday.
Submit by Monday.
Monday.
Submit by Monday, and copy will be accordingly furnished to Swens. Considering the interest submission made by learning counsel for both sides, let the matter be accordingly listed on 22nd of this month for scan copy of the TCR and the case diary. List accordingly. Okay, we are listing it on 22nd.
Lordship.
And see to it what kind of
Yes,
documents
if
he
required,
he
we
want
will
to
ask
tender.
request for time, otherwise no.
No, otherwise.
Highly obliged.
And just kindly
I will give the excerpt from
yes,
the,
yes. Otherwise, it will be difficult.
the
on all.
documents or the materials which
Yes,
we
yes.
like to
Materials which
rely.
have collected against
We'll
the
make it
present
convenient
petition
to the
can be
honorable court.
like.
And if required, we can give a call. Oh, no, we cannot give to the other side. We'll give to the honorable court.
Okay. Sure.
Highly obliged.
Yes.
Lordship, impugn order dated 8/4/2026. Madam, my petitioner's bail was rejected by the learned session just late. And he was arrested in connection with this case 11/3/2026.
11/3.
Lordship may Perus. Chargeable matter.
Of yes, it's charge sheeted.
Charge sheet.
What is the stage of the case?
Examined.
How many? How many witnesses?
Few witnesses have been already examined. Charge was framed. Although charge was framed under section 376(1)(n) and 417, but so far as the FIR is concerned, there is no any ingredient of 376(1)(n) and 417. And Lordship may peruse.
Now, see, the question is that obviously at the time of instituting or lodging the FIR, there may not be some ingredients may not be there, but during the investigation, after recording the statement of the victim and all, those sections might have attracted, and for that.
Originally, section was added by 366. Even the 366 ingredient is not there. Then after framing of charge, it was altered to 376(1)(n) and 417.
Obviously, court found that there are materials.
Yes.
In the statement of the victim and all. That's why charge was altered, and then accordingly it was framed. Finding need of framing charge under section 376. So that was there. So now the question is that we are not basically on merit of the case now, as case has already been charge sheeted. So let the scan copy of the T series. It is from Teshpur.
My lord, yes. Annexure 6, page 31.
Yes.
Page 31.
Yes.
Accused Dipondati Bora is in the bail application file on behalf of accused Dipondati Bora. Peruse the case record, and it is seen that the state accused was shown as absconder in the charge sheet, and thereafter.
Oh, he is absconder. He was
Yes,
absconder.
my lord, absconder means police did not visit my residence. Even no any information from the police that one case is pending before the police station. And when someone was issued by the learned CGM court, I have appeared by an advocate. And the very last day, my lord, very next day, my lord, I met in one accident, bike accident, and there was severe injury was there, and 18 number of stitches at different parts of body.
Okay, then he was absconder, but at present case is pending or the
Record with
evidence is
purposes.
going on, so it is not the matter whether he was absconder or not, because now he is facing the trial, and the evidence is already recorded. So he may be an absconder, but at present it's not required. Now we'll call for the scan copy of the T-set to know the case and whether, as per your information, victim's statement have already been recorded.
Yes, yes, ma'am.
It is recorded.
Record.
So let us call for the scan copy of the TCR along with the case diary. And the status and the present status report. Yes, when it can be, Purva?
Purva?
1st of June. 1st of June will.
Short date may be given because his wife is pregnant. Date of delivery is 8. Date of delivery expected date of delivery is 8. $17,800. $17,800.
17.8 and 1.6 is okay.
Next, my mother and child card, and it is reflected that 17,800.
What to do?
Therefore,
In that case, 28 of May.
28 May.
Expected delivery is there, to what to do? Charge sheeted. What is the stage of the case at present? It's 103.
103 is actually.
Acha, how many witnesses have already been examined?
No.
No witnesses? Okay, we're
Okay,
calling for
but-
the scan copy of the TCI along with the case diary. Let us see the position. We'll see. Your petition is in custody since when? 1812.
1812. First one.
Almost 6 months. Scan copy of the TCI along with the case diary be called for. Registrable duty needful.
First of June.
Okay, 1st of June.
4.
Yes.
Regular bail application with process. That is at page 9 to 19.
Page 19.
Page 9 to 19.
9 to 19.
Altogether, there are 10 accused persons you lost. So I am not for others, you lost. I am here. He is arrested. I am for accused number 1, you lost. Allegation in a nutshell, you lost with accused number 1 again. That informants brother-in-law on Dilwar Hussain. And also another person, Babul Hussain. Both of them were assaulted with batons, you lost it, wooden object, you lost. So otherwise you lost it. The whole dispute you lost it is arising out of land dispute, and in the FIR is also reflected you lost it. That due to some activity enmity. Enmity is arising out of land dispute. So what happens is that you lost it. The accused person, they purchased a plot of land from the informant you lost it. Long back you lost it. So accordingly, mutation was granted, you lost it. So next you lost it. Possession has not been delivered, you lost. So time and again you lost it insisted. The last of them, the date of incident you lost it. That day only you lost it, insisted because long days already elapsed you lost it. So therefore, that day you lost it, some altercation had taken place. So this, in order to just avoid to hand over the possession, this if you lost it, he has been assaulted with batons, wooden objects. Certainly would have been admitted in the hospital. There must be indication of the name of the hospital, how much time it was undergoing treatment. There's totally not, there is no single voice for again. Only just to implicate.
The victim was not admitted, not even admitted in the hospital.
That's a, you lost vicinity of the very, you lost close vicinity, you lost. Yes.
The undergoing treatment in a critical condition is there. So you are saying he has not taken any treatment, but here it is written that Dildar Hussain has been undergoing treatment.
But you lost it. They have indicated here that certain treatment in a critical condition.
Now, why are you submitting that he is not even gone for any treatment?
But
There's
this
no
is
mention of hospital.
Huh?
There is no mention.
No mention.
No
Where,
mention
where?
of hospital. In which hospital the injured was undergoing treatment.
See, we don't know, but the now 1181 is there, 109 is also there. So we are calling for, since 85 he is in custody, na?
So in a forwarding, it was FRU hostel Moria, but it was examined. Lordship, at this stage, case diary along with the injury report.
Made be lordship on 22.
22nd of June,
22 now to 22 is not at all possible.
2nd of
2nd of June.
Second of lordship.
It will be, yes, only 1 month, 4, 5 days only.
2nd of June, lordship.
Yes, 2nd of June.
Made be on 28, 29, 27 is the ET, lordship. Made be on 28 or 29.
No, 29 to 22 to both way. No,
Lordship,
not
lordship.
possible. 2nd.
And another item is lordship, item number 11, arising out of the same
Second.
FIR, lordship. Here it is the anticipatory bail
Item
application,
number,
lordship.
item number.
11. Maybe taken together, lordship. So here may not have some submission.
Item number 11, no?
11.
Yes. Yes, Mr. Chairman. Yes, what do you want to submit here?
So here in this case, some ladies have been implicated in lordship. Ladies. So there's no.
Here the petitioner is Mujibur. Oh, no, sorry. Mustafizur.
Petitioner is your lordship Mustafizur and 6 others, your lordship. So they're all named in the page 10. May kindly be looked into, your lordship.
Ah.
So my submission is restricted to your lordship. Actually, what happens is that, your lordship, there is some altercation between the female members of the two houses. They're at the vicinity of the house, your lordship. So accordingly, your lordship, when some altercation took place, the male member came forward. So my submission is, your lordship, here is this, that although there is an allegation that assaulted with batons, wooden object, are admitted to hospital, my submission is as to whether all the accused person against some of the petitioner, your lordship, only pitched and kicks, and actually they are not at the place of occurrence, your lordship. An allegation against them only pitched and kicks, your lordship. Someone is, your lordship, that theft of fear of the, your lordship, female member, that is informant, pulled out, your lordship, and then some pitched and kicks. So main allegation is, your lordship, against Abdul Jalil, who has been already arrested, your lordship. So my submission at this stage, your lordship, interimly granted, your lordship, and on the same date, your lordship, the city may be called for. So I may be allowed to record my statement before the city will cooperate all the way. Whatever conditions will not do, team fit and proper. Just to after recital of the FIR, verify as to whether interim could be granted or not. But again, 10 numbers of this person. Generally, what happens is that, your lordship, when two, three person living the, your lordship, the place of occurrence, other members are generally implicated just to.
So after perusal of the case diary, it will reflect whether their involvement is there or not also.
Only pitch that speak.
See, I was just going through the FIR
Okay.
only to see the involvement of the accused petitioner.
Lordship.
I thought that some of them, their involvement may not be reflected in the FIR, but every involvement of the every accused petitioner is reflected in separately in a very thing way. So it's not a case that one has done something or one other one has not done anything. It's not a case. Every one's involvement is specifically mentioned. So let the cause call for the case diary on 2/6.
Whether there is an unlawful assembly or not. Unlawful assembly, whether they formed an unlawful assembly. So that is.
So only unlawful assembly forming of unlawful assembly will amount to anything, but otherwise there are evidences. So let the case diary, you are not on jail, you are on you are outside. So okay, we'll listing it on 2/6 all the matters 2/6
At least 2%.
2/6. Okay, CDB. List the matter along with BA 1251 of the 2026.
Matter number 5.
Must have labor.
Made in the not casted matter. I didn't want to find that was by the in my second video. There are three essential facts. Also, may kindly the FIR at page number 10. FIR at page number 10. Page number 10. Operative part. Sir, with due respect, I would like to state that on the night at about 2 a.m., the opposite party set fire to my house. This incident has arisen due to a long-standing quarrel between my sister's husband and the accused because of an extramarital affair involving the accused wife. In a fit of aggression, the accused committed the act of arson, resulting in the destruction of Gautam Ghosh's shop by fire. With the help of local villagers, I managed to extinguish the fire. However, property damage amounting to approximately ₹50,000 was caused. My father witnessed the accused fleeing the scene after the fire was set. Therefore, I kindly request to take proper action. Lordship, the time of occurrence is given as 2 a.m. in the night, and as per the charge sheet, the age of the person who was seen is around 67 years. However, Your Lordship, another essential fact is that on 16th of March, this alleged occurrence happened. 17th, he was forwarded to the judiciary, forwarded before the Iraqi magistrate. 18th was the third Saturday, and 19th they have filed the charge sheet. They did not wait for any further investigation. Within 4 days, the charge sheet was filed. Your Lordship, here the entire incident is that the accused person who is behind the bars with his wife, his informant's sister's husband has an alleged affair, Your Lordship. And the fire has not happened in his house. There is no mens rea against the informant. It has happened in the adjoining premises of someone else, and taking advantage of that fire, this was the affair. And at 2 a.m., there is no other independent witness in the charge sheet also to establish that he was the person who started the fire. There is no report of the fire department which says how the fire occurred, and therefore he is still around 28 days behind the fire. Charge sheet has already been filed. May I be given the liberty to participate in the trial?
Yes, Kusam.
Lordship, record may be called for at least a charge sheet file along with the case diary. Because without going to the case diary, because setting a fire rape damage the property, Lordship, it's a serious offense, Lordship.
So what is the stage of the case at present?
Just appearance stage. Those charge
Just
sheets happened in
appearance.
4 days. 4 days.
No, I'm not on that. It is in
Appearance.
appearance stage. Yes, can copy of the TCR along with the case diary be called for. Yes, the rest you will do in it. Borwa, it
Pardon? Before 26th May.
May 20, they're not at all possible. There are many matters are already been fixed. 22nd is also not possible. 27th is a holiday. 26 already many matters have been fixed on 26. May not be possible.
On 30th.
Let in 1/3 of June.
Six.
Yes.
Not when it.
Mm.
This item may be come to the Lordship, item number 34.
34.
Yes, it is the same city Lordship.
So along with the 34, 34.
34. Okay, it will come along with 34.
Yes.
Okay. Yes.
We should be talking with the this case bank. What is the inform? Kilo. Personal loan of this in lakh. Car loan of 9 lakh. COVID loan 4.9. Initially, the salary account of the individual was the state bank of. He subsequently, because without our already transferred to the state bank of, and he stopped paying fees. So thereafter, there was a default. In fact, we got two money suits have been filed so far the other cases that are there, other loans are there. So for the vehicle is concerned, the first 9 lakhs, total amount was 9 lakhs, it was be paid 84 EMIs of this 40,500. The loan account became empty on 15/2/2024. Thereafter, after due notice and all, position was taken on 14/5/2024. Now, thereafter, three sale notice was issued, and thereafter, the vehicle was auctioned. And in fact, after the whatever the payment was made, the lordship will find it at page 40. It was adjusted in the loan account of the EPOM. So the state account will lordship at page 34. And the relevant at page 40. 34 lordship is section 82. Term is 84. Number of EMIs left 35. And after it was sold off at page 40, an amount of is 4,40,611 credited into the account of the. So what has happened, Initially, lordship will kindly come to before I take you to the FI, page 41. Here, initially he lost an FI. Because later that thereafter an inquiry was done.
Who lost?
The informant. This is the third effect. Because the first effort, an inquiry was done. So I'll just take it to the fourth line. During the inquiry, it was revealed that while Napoleon Maji, that is the form, was posted at KV Sonapur, he availed a personal loan of 18 lakh, car loan of 20 and COVID loan of 4 from SBI. However, the component changed his salary account from SBI to EBI, as SBI Sonapur was unable to deduct his EM. Subsequently, the component has not been paying his regular EMI for personal loan. Currently, the company is posted as KB, 30 Road. While the component was not paying the vehicle loan, vehicle number so regarding vehicle number so reposes the SBI Sonapur reposes the vehicle as per the laid down instructions that took action against the state vehicle. The inquiry revealed that approximately rupees 12 lakhs of SBI Sonapur bank loan EMI has not been paid for the last 1 year. In this regard, the branch manager SBI filed a intimation at Sonapur police station and the Jagiroad police station regarding the fact. During the inquiry, the complainant was asked to appear before the inquiry for examination of the facts of the case, but he did not appear before the inquiry officer. If the complainant appears before the inquiry, the matter will be reinvestigated if required. The lordship next page that it resulted in closure of the case. The police report at page 40.
No, the present FIR, where is the present?
That is not. Therefore, what he did, he lost a complaint before the court of CGF. So, lordship will find it page 20. Now, I'll just take you to paragraph 2. He admits that he has reported in payment. Page 21, lordship. Paragraph 2. The complainant purchased one vehicle, namely Toyota Urban Pushia, petrol bias to and accordingly, hypothesis has been created over the state vehicle by the bank. By loan number so the state vehicle has been registered under registration under the EQ number. At last on 16/5/2024, this was complaint was filed 11/3/2023, and vehicle was repossessed on 16/5/2024. One agent of the state financer has appeared at the residence of the complainant and he has forcefully seized the state vehicle. As the complainant has defaulted in making payment of the few years, there is an admission on his part. Thereafter, the state fund has informed the complainant that they have already sold out the state vehicle of the complainant through e-auction process as of on last 16/1/2025. But shockingly, as of 14/9/2025, the complainant has come to the state vehicle. The complainant is being illegally used by some unknown person. After it is auctioned
option, it will necessarily be used by some other person. Now, this is his basic delegation. Unknown person has been so and so with this without his consent by using some forged documents of the complainant with the help of the aforementioned accused person. Now, prior to that, in a paragraph 3, the complainant is filed an hazard at the office of the Director of Police Station on 5/10/2025 against the instant accused regarding their fraudulent action, but no action has been taken as well. So this is his allegation below. Thereafter, if your lordship kindly comes to page 15, the judicial magistrate below first class, he refers the matter to the following. And after this case, this case was stated. Now, what the branch manager can do, Milord? Here is a default. Vehicle was taken over possession long back, was sold off on auction. Milord, I have appeared before the IO Milord twice on 8th and 10th of this month. Now, Milord, the IO is that Milord, I recover the vehicle and produce it before the police.
Where is the FIR of this present case?
This is the effort. This has been registered, Milord, page 15, Milord, if lordship kindly comes.
Answer as complaint.
Complaint, Milord, it was sent to the police station for registration.
Acha.
The order is at page 15. So what is the first manager to do, Milord? As per the High Court, he himself claimed that he has got it in payment, Milord. And in fact, Milord, we have lost number of FIRs. If the lordship sees, the notice is at page 25, and it's a D. 20, 25, 26, 27. Milord, then we wrote to the employer, Milord, at page 28. Milord, thereafter, from case 30 onwards, Milord, FIRs were lost by the bank. In fact, Milord, at page 33 is the sale notice prior to Milord the auction. That would be relevant, Milord. That was on 22/12/24.
At this stage, lordship, investigation is very required, lordship. So, that after the record, we have to go through what is his role and involvement, lordship. So, call for the record, lordship, at this stage.
Your option was dated?
16, that is in the complaint itself. 16/1/25. In fact, Milord, one after another FIRs were lost, the lordship has seen. First, it resulted in closure. Next, Milord, we are not aware of the 510, which is mentioned. Now, how is the branch manager involved? That is, Milord, breach of trust, cheating, or criminal conspiracy. How does it come, Milord? Otherwise, Milord, lordship is aware of Anup Sharma's case. So, no criminal offense is made out, even if the vehicle is sold. He says that if after auction, the vehicle is being used by someone else. It's quite natural, Milord. After disposal, if I sell off a vehicle, Milord, it has to be used by someone else. Milord. How the bank officials are responsible for it? And it's not that, Milord, the money has been diverted to my account. It is in the loan account of the petition. Sorry, for me. Milord, in fact, Milord, I have.
Mr. R.D. Mr. R.D. Dilan for the petition. Also, Mr. D.P. Goswami. Dilan additional PP appearing on the state of the law. It's an application under section Swenson in connection with Swenson. Mr. D. Dilan submitted that the present FIR has been lodged against the branch manager who cannot be where there cannot be any ingredients against the petition to register a case under section 3182 and 316 subsection 2 and 316 subsection 5 as registered against him. If it is submitted that the informant took 3 loans and out of which for 2 loans there is money suits are pending, and the third loan which was taken for a vehicle and for the vehicle. But submitted that there was supposed to cut the EMI in 84 installments, and after cutting after some installments, the informant had changed his salary count, and for which bank was not in the position to deduct the EMI. and for which there was a use. There was a due, there was a, and for which the demand notice was also issued by the bank in various occasions. But instead of receiving so and so demand notices, he did not pay the money, and finding no other alternative, issuing a sale notice on 2012-2024. The vehicle was auctioned on 16/1/2020. After deduction of the loan amount, after adjusting the account, the remaining amount from the auction sale was deposited in the bank account of the informant. Stocky further submitted that it is alleged that the vehicle is using by some other person, which is very obvious, as after the auction of the vehicle, it is in use of some other person. However, the petitioner appeared before the IO on two occasions, that is on 8th of May and 10th of May, and extended their cooperation. Extended his cooperation. He is further ready and willing to extend his cooperation in the investigation of this case if he is provided with some interpretation. Next point. Mr. Goswami, in another edition, PP raised objection and submitted that city may be called for to know the actual fact of the case and the involvement of the present petition. Next, considering the circumstances, other aspects of the matter, the court is of opinion that the information may be provided the present petition till receipt of the case. Okay, will be provided with some information. Yes, Goswami, when it can.
8th of June.
8th of June?
Not
I'll let you with that. I'll let you with that.
Yes. Time being.
I
Yes.
Can find FIR
Page 8.
Irrigation 103 with the FIR. Court FIR. Stated on 64/2026 at about 5:20 o'clock. My minor daughter, namely Sri so and so, is about 15 years, committed daughter suicide in her room of her house by hanging from ceiling fan by her children. I took her to get out, but the doctor declared her dead. We have noticed a number of incoming calls from the mobile number so and so to her mobile number so and so before her death. We have come to know that the owner of the mobile is Pawan Khandar. We suspect that she was mentally tortured and blackmailed from that mobile, for which she has committed suicide. Actual fact of the case is that the petitioner and the victim are really in love affair, but they are from different castes. Therefore, the parents of the victim are always objected and force the victim to cut off every relation with the petitioner. And in that regard, she was often subjected to physical and mental harassment. Dr. May now kindly find some message, WhatsApp message exchange between the petitioner and the victim on page 14. Second message, I am skipping first 5 lines because this is about her disease lordship. She was suffering at that point. বিছনার পৰা উঠিলে মাথা ঘূৰাই তাৰ ওপৰত মা পাপাৰ গালি মাৰবোৰটো আছে কান্দিবও নোৱাৰো উশাহ ল'ব বহুত কষ্ট কৰে মই নোৱাৰিছো মোৰ ফিজিকেল হেল্থটো ঠিক নাই যে মই কিবা সহ্য কৰিম ইয়াৰ অলপ কেতিয়াবা ভালকে থাক অলপ কথা পাত মই পাগল হৈ করিম দুদিন পিছত দেন নেক্সট মেছেজ লৰ্ডশ্বিপ ৰূপ তোৰ এতিয়াও ডিষ্টাৰ্ব নকৰো কল মেছেজ নকৰো কল মেছেজ কৰি then he was suffering from fever also and I suggested her to take medicine is 15 fourth message লৰ্ডশ্বিপ message জ্বৰৰ টেবলেট এটা খাই লো I have sent it back. Then Lordship kindly say page 16 there are some messages. He was always telling that he was subjected to physical and mental torture by her parents. Lordship kindly see from the first message Lordship একো ঠিক হবলে নাই নাই যি হবলে আছে হৈ গল মোৰ ঘৰত থাকিলে বুজিলি হয় then Lordship kindly see মোৰ ভাল পোৱা কি মোৰ পাপ নেকি ইয়াৰ মোৰ লগতে কিয় আৰু কিমান কৰিম মই পাগল হৈ যাম then she is alleging her father Lordship next message কালিৰ ভিতৰত যদি পাপাই একো নকয় then পাপা মোৰ পাগল হৈ গল লুকাই থাকিব লাগে মোৰ পাপাক দেখিলে নি চেপি ধৰে ডাইৰেক্ট these are the messages exchanged between the petitioner and the victim card and therefore she committed suicide Lordship. But the informant is the father of the victim girl. He is alleging that the petitioner has subjected her to commit suicide. Everything clear?
Anyway, that might be true, Lordship, but a minor girl was committed suicide, Lordship. So we have to peruse the case diary. Is nothing found that it's okay, Lordship, but at this stage, I pray for case diary only.
But from the back of the case, I deserve Lordship in this topic. Kindly,
But that message is from which date it was sent?
yeah, but I never subjected her any mental or physical torture.
But at this stage, only case diary. After peruse of case, the Lordship will decide.
Fever, I must suggested her to take medicine also Lordship. That from preparing the and she is saying that her father inflicted all these mental and physical torture also. These are her estimate. Can we protect me? I will provide any condition me.
So I might say the land council. So hard to because of it's an application. It is submitted by Mr. Hussain. The explanation he has not committed any such offense as alleged there. However, it is a fact that if this petitioner and the victim were at love affairs, but coming to know about their the family members, basically the parents of the victim, used to torture her both mentally and physically, and she used to report it about the same to the petitioner through SMS. Some statement made in the SMS is also annexed along with the petition. He further submitted that the victim had committed suicide only out of the mental and physical torture inflicted on her by her family members. However, the petitioner is ready and willing to extend his cooperation in further investigation of this case if it is granted with some interest. Next one. Mr. Kusami, the learned additional PP submitted in this regard that city may be called for to know the actual fact of the case, as one minor girl had committed suicide. Considering the submission made by the Proceedings and the materials annexed along with the petition, this court is of opinion that one opportunity may be given to the present petitioner to appear before the alia and cooperate in the investigation of this case. And the is to extend the privilege of the pre-illustrate the receipt of healing. Okay, will be under interim protection. Listing it on 8/6.
And
medical. It's here, two petitioners. Case, it is affair. I am reading a Pankola is 12. It's a counter class of our affair. It's 12. Because
Hmm. Yes,
so
please.
the notice date here, 6/4/2026. 6/4/2026.
Hmm.
Gauhati, 5/4/26 তারিখ সন্ধ্যে অনুমান নিম্নলিখিত পদক্ষেপে আমার ঘৰত কোনো অন্ধকাৰ জোৰ জবৰদস্তি ঘৰৰ ভিতৰত অনাধিকাৰ প্ৰৱেশ কৰি ঘৰৰ ভিতৰত থকা মহিলা ধৰি প্ৰাণী মৰাৰ প্ৰদান কৰে কৰাৰ ইংগিত কৰি ভাৰতৰ ডাঙৰ পৰা পুনৰ এই ঘৰৰ ভিতৰত নষ্ট কৰি লগত থকা 5টা ছাগলী 5টা ছাগলী আৰু 6টা গৰু জবৰদস্তি লুট কৰি লৈছে Ramzan Ali, all are family members. Ramzan Ali and Bodhipur, I am for the petition is the case number 2 and 8 years. All are family members. Now you are our affair. Case 16. That affair lost next year. Our case 16. The top is the date of affair 5/4/2026. I am reading your. Mark of the Nivise. I think 5 तारीख আপনি তাই দিন রোমান কথা মই রাস্তা আমার লগে নিম্নলিখিত পদক্ষেপ এবং রাস্তা বাটা করি কাজটা করার উপরিও মুক্তার টুকুরাকে মূৰত মারপিট করে জখমপ্ৰাপ্ত কৰে শৰীৰৰ বিভিন্ন ঠাইত মাৰপিট কৰি জখমপ্ৰাপ্ত কৰে পিছত ওচৰৰ পাজত থকা মানুহে বাধা প্ৰদান কৰাত কোনোমতে মোৰ প্ৰাণ ৰক্ষা কৰে This affair is registered as duplicate case number 137. 137, registered under 126, 296, 1181. And instead affair is next day, they have lost the affair. Duplicate case number 138, 23. No incident was sister of the case number one Omar and Monu in our affair. The sister lost next day, getting some illegal. They belong to the same villages. They are looking the daytime. It's not possible to take 5 cow, 20 numbers of cow, 5 numbers of God purpose. There's more than 500 for the living that day. In fact, it's something different. So I'm stating paragraph 4 of my petition. Page 4 here. Paragraph 4, page 4. That there is a boundary dispute between the petition from family members. The informant's family members encroach the boundary of the agricultural field, the petitioner. And on 4/4/2026, at about 9 a.m., an altercation took place between the two families, the two groups in the agricultural field. On 4/4 incident took the altercation. Therefrom, next day, 5/4/2026, the family members of the informant taking the chance of alone the customer one Ramzan Ali, the brother of the one. On road or with on physical asserted. In this respect, he lost an affair and is registered at duplicate 137. Next day there.
Yes, Usami.
Yes, but we have allegations are for dacoity. Dacoity is a serious offense, so
They died. 5:30 a.m. the next day.
This is registered under dacoity.
310-2.
Yes. It is false. Daytime state test and
Also, 310 is there. Now, see, two things can be happening. Either obviously, as you have submitted on the earlier day, that is on 5/4, one incident had happened at about 2:30 when the brother of the petitioner number 1 got sustained injury, he was assaulted. You cannot deny that out of that grudge, the petitioners, that is your family members came to the house of the so and so and they did. That cannot be a thing.
Daytime taken away 20 numbers of cow in the daytime.
That's why this dacoity section, dacoity is also there. I think. Dacoity case, how can you intervene? Obviously in the daytime, not in the daytime, in fact, it was on the evening
Evening.
time.
Record, the-
Fine.
the sales letter.
Mm.
All are taken.
Okay, let us see the case diary.
Protected with cooperative.
CDB call for. Yes, when it can be?
Third of June.
3rd of June. 3rd of June will do? Okay, 3rd. Interim we are not providing. I thought of giving interim, but later I thought it's a history case under docket.
Provide. Thing is taken, I think it's separate here, but taken as.
Quite surprising that in the how such number of things can be. Mm. I do admit this thing because it is quite, I mean, it is not so can be believable that 20 numbers of cows can be given. Anyway, 3-6 we are giving.
This is charge sheet submitted, Lordship.
Charge is submitted.
Lordship.
What to pass the order or what to do?
Non-appearance. Was this yes? One of the some. Each should be. But sometimes Lordship, if he
Or we can dispose of otherwise. If case has already been charge sheeted, they are on bail, I think, or interim.
not
They are on interim.
yet
Which item we are on? 19,
19.
isn't it?
in here charge sheet submitted on 12/5/26. They have filed a petition on year first date on 4/5/26.
Oh, it was called for only for accused number 2, Mia Hussain. But can you tell us whether Mia Hussain is charge sheeted or not? Others are on bail. Others are on bail.
Ikram Hussain.
Mia Hussain.
That is not reflected in the information, Lordship. Only charge sheet submitted as case number is 0.
Okay, yeah, it's just good. Non-appearance on call for the petitioner. Heard Mr. B. Goswami, D.P. Goswami did an additional PP appearing on behalf of the and it is submitted that case has already been charge sheeted by CS number
Right, CS number 11626 dated 12/5/26.
12/26. In view of post. Next order. Further, it is seen from the order dated 4/5/2026 that the accused petitioner number 1, 3, and 4. 1, 3, and 4 are already granted with bail. And the case diary was called for only for the accused petitioner number 2, namely Mia, namely Mia Hussain. Namely Mia Hussain. In view of this, accused petitioner number Mia Hussain is hereby directed to appear before the learned trial court below with a regular bail application, which may be considered in accordance with the above observation. They present the PS test.
20.
When Lordship, we have not received a case diary. Petitioner is an interim. Up to
are
the CDS call
interim.
for that is not received.
CD not received, this reminder.
It-
Yes, when it can be
9th of June, Lordship.
9th of June.
It's from Dhubri.
9th of June, interim be continued. Yes, we continue your entry.
21.
Yes, what is the position of 21?
21, Lordship, we have received a case, but statement of the accused, he is on interim, Lordship. State,
What arrested the case. He either benefited or we have lost contact with the was arrested. Whereabout, I don't have any clear instruction regarding his whereabouts. He will be given. He has been arrested in some other case.
Acha. Heard Mr. T. Laskar, Delaney, counsel for the petition. Also heard Mr. D.P. Goswami, Delaney, additional PP, appearing on behalf of State Department. It is submitted by Mr. Goswami that the case diary received, but the statement of the present petitioner is not available in case diary. Though the petitioner is on interim bail. Next paragraph. In that regard, Mr. Laskar, Delaney, counsel for the petitioner, submitted that after obtaining the order of interim period as bail, it was informed, submitted that it is informed by the wife of the petitioner that after obtaining the order of interim period as bail, he got arrested in another connection with another case, and at present his whereabouts is also not known to the council. In view of this, he submitted. In view of this, let the matter be listed. You can send it back, otherwise we don't have any alternative. We're listing it on list on 2nd of June, enabling the learned and this council for the petitioner to take instructions in regards to his whereabouts. Further, the CDB return calling for an updated one along with the statement of the petitioner if already recorded, and if it is not yet recorded, the petitioner is also hereby directed to appear before the IO and to record his statement. List the matter 3rd of June, 2nd of June, so and so. Interim be continued till next year.
24, in this case, Lordship, FR submitted.
24.
24.
None appears on call for the petition. It is submitted by Mr. Goswami. The case in the present case, the FR number is there.
FR number is there. FR number
has been
13 of
submitted. 13.
13/26, dated 29/4/26.
As the case ended with FR, the anticipatory bail petition has become infructuous, and accordingly
25.
25, Lordship, we have received the case diary. Case diary updated on 11/12/25. So petitioner is on interim, but his statement is not here, Lordship. Interim was granted on 17/3/26, I think.
and your
Update is 11/12/25.
Oh, 11, 12.
So updation is required, Lordship.
As per, do you have any instructions in that regard?
I have different, I have given my statement. I think cooperating and, I'd like to place one paint here. The informant has instituted a civil court. Same time.
Already instituted.
So we've sent back the case diary after updation. We have a statement of the case petitioner also.
You are Mr.
And
N.K. Sharma. You are appearing for someone?
my name is there in the Wakalatum, but it will come in the CI.
N.K. Sharma.
Yes.
Heard Mr. N.K. Sharma, the learned counsel for the petitioner, and also heard Mr. P.P. Goswami, the learned additional PP, appearing on behalf of state respondent. It is submitted by Mr. Goswami that the CD is not updated one, and the last entry in the CD
11/12/25.
11/12/2025, and the petitioners got interim on 17/3/2026. However, it is submitted by Mr. Sharma that as per his instructions, the accused petitioner had already appeared before the IO and cooperated in the investigation. Next, in view of this, let the updated case diary be called, returning the same, and the IO is hereby directed to furnish the statement of the petitioner along with the case diary, if already recorded. List the matter accordingly when
10-6, it's some
10-6.
room number.
10-6. Interim be continued till next day of testing.
Item number 24. Proceed may be submitted.
FR submitted, Lord Ship.
This is FR submitted.
Right.
So we disposed of the matter.
26.
Just a second. What is the 26? Just a second. CD received here?
You received.
Ouch. FR is at page? 8.
In this case, Lord Ship, the POXO is later on, POXO is added. 6 of POXO,
6 of POXO.
Lordship.
6 of POXO means
The notice should go. Notice.
then it cannot be a case.
It was 87.
And case with POXO, no?
POXO is added, na?
Main indication not in but case with POXO, that is the problem. It was dated, order dated 29/4/26. It was added section or 64 to BNS, added section POXO, 6 of POXO.
Oh,
So we have to send notice to the informant lodges for the guidelines. The POXO is not in for the main accused, but it is not. But the whole case is against the POXO is added, so notice should go.
First item, Lordship, I will submit and according to Lordship, I will have the notice.
Mr. M. Khan, the learned author for the petitioner. So Mr. D.P. Goswami, the learned additional PP appearing on behalf of state. CD received, but it is submitted by Mr. Goswami that section 6 POXO has already been added on the prayer made by the IO. Why it's order dated, Ketia? When?
Order dated 27/4/26.
27/4/26. In view of this, Mr. Khan submitted that he may be allowed to amend or correct the cost title incorporating the name of the informant as a respondent number. Prayer allowed. Mr. Khan will accordingly file an additional affidavit or for correction of the cost title. And cost title, and after correction of the same, the notice may also be issued to the informant of the respondent number. Let the matter be accordingly listed on when you are going to. Monday is not possible. This week, though, we don't have.
Yes, you lost it, but I take it
By
because
Monday.
I have to submit the
Cost title. Monday, not Monday, Tuesday, Monday, Wednesday. 19 is Tuesday. 19/5. CD, going to return the case diary or you can retain it. No, but after retaining also you have to issue notice, then
notice
someone will
and,
come. It will again create problem.
whether notice up or not. So for 3D is concerned, Lordship, I think.
We'll call for a CD again, Lordship, no problem. Yes, from
CD retail.
retaining is long in a long period, retaining the CD is difficult.
Because till now, till that he have to first amendably corrected the cost title, then notice has to be issued.
You lost.
And it is not a case that on the second day itself, you will take instructions from the, you have to take notice
Your Lordship
to public prosecutor, it will go, then the inquiry can be done. Otherwise, how can?
Your lordship may pass order directing me to submit the court packet and on that very day lordship will take a step. That order your lordship may pass.
No, it is already passed.
Yeah, regarding the step.
Unless and until you cost M&D cost little, however, I have made this observation that after correction of this step will be taken. I have already made the observation. But even if it is supposed fixed for that purpose on 19, but CD.
We'll call the CD again. List is over. Any date on it will be on June. Then we'll call for a CD again. No problem.
CDBC
List the
Investigation
matter
can be-
accordingly on.
If
We
police
can list
require
it
the
on
CD, then we
19,
have to keep.
no issue. But
send it.
thereafter it will be returned back, I think, na? 19 corridor 19.5. And CTB return accordingly, which will be called for subsequently after appearance of the respondent number 2 of the. Otherwise, we are fixing it on 19.
There's an interim order that will.
Sorry, interim be continued till next date.
May it please your lordship regarding item 19 lordship is the.
It is
They have filed a civil suit for the recovery of the position. But while we are harvesting, they entered to our land. And there was a market, there was a injuries from both sides. And there are two petitions. One is the period bail, one is regular bail. Out of the period, 2 persons, 70 years old and another 35 years old, of my family were arrested. Now the other person against whom the similar sections of cases are there, but they have not yet been touched by the police. And your lordship, the other day CD has come, but your lordship, there was the statement of the person. So your lordship called for them.
Medical report also called for your lordship.
And my lord, they also have given the medical.
There is a grievous heart, my lord.
And all are now recovered and came back to home. But there are serious injuries on our side, my lord. I have annexed the, my lord, this civil suit they have filed, my lord, at Kokrajhar court, my lord.
Civil suit is
For
another.
the recovery of the position. But they are the aggressor, my lord. They have entered to my land. Yes, they have filed the civil suit. They should wait for the judgment of the civil suit. It is family, both families are same family, my lord, for the recovery of the position. If they have got any shares, they have filed the case, but they should not have taken the law in their own hand. They have taken the law and they attacked us. Then we also give a repulse the attack. There are injuries from both sides. All were treated at GMC, and some were treated in Kuch Bihar. Nowadays, 27 days we are behind the bar in the PA.
Yes, Mr. Shah.
Yes, Lordship will kindly take up the BA for a moment, Lordship.
BA.
BA. Lordship has taken it.
Yes.
Yes, Lordship will kindly come to the forwarding report at page 34.
34.
Yes.
Yes.
Lordship has found it. Lordship, I am not going to the all the details, Lordship. Lordship will kindly come to the brief of the case. Here, Lordship will, from the down below, Lordship will kindly come to 1, 2, 5, 6, 7, 8 line, Lordship. Oh no, I'm sorry, Lordship. Just a minute. Lordship will kindly come to 1, 2, 3, 4, 6. From the top, Lordship will kindly come to 16th line from the top, brief of the case. 16th line, Lordship. It in there it will Lordship will find in this incident Azizul Haq sustained. Lordship has found it?
Yes.
Yes. Lordship will kindly, I will slowly read Lordship. Azizul Haq. This is the Lordship informant side, Lordship. Azizul Haq sustained grievous head injuries. Both legs were fractured and he received multiple injuries. Ayub Ali sustained grievous head injuries and his left hand was fractured. Sofizul Islam sustained grievous head injuries and his right leg was fractured. Rosanara Bibi sustained grievous head injuries and her right hand was fractured. Meherun Nessa sustained grievous head injuries. Nazimul Islam sustains grievous head injuries and his left hand was fractured. Other victims also sustained injuries on different parts of the body. The accused persons carried out the attack with intention to kill and thinking the victims to be dead, fled away, leaving them in the field. Now, Lordship, in respect of two victims, Lordship, the medical report is there. It tallies with the forwarding report. Their legs were fractured and they suffered serious injuries on their head also. And the respondent number 2, they have filed one affidavit there. They have annexed the photographs of the Lordship. Lordship will see. Now, Lordship, here, whether this is a two group, they are fighting civil dispute, we are not concerned with that. There is a commission of offense. The informant side, Lordship, they were dealt with blows, injuries were sustained, and Lordship, the intention was clear, Lordship. It was supposed to kill them, Lordship. They wanted to kill them, Lordship. Because the injuries that cannot be of a simple nature, Lordship. Will see the photographs. Legs were broken, hands were broken, head injuries, Lordship. This person, if Lordship, they are released on bail, Lordship, again this will happen. That is for sure, Lordship. So that is my respectful submission. And the injured statement is there, Lordship. They have implicated all the accused persons. I will just point out, Lordship. The petitioner in the AB, Lordship will find the petitioner number 1, he has already been arrested. And therefore, this BA was filed, Lordship. So, Lordship, 1, 2, 3, 4, 5, 6, 7. All these persons are named, Lordship, specifically named. Only 8, 9, 10, 11 are not named by the injured. But they have stated, Lordship, as others also. So, there is every chance, Lordship, that they were also present there, Lordship. But specifically, Lordship, to be fair enough, 1 to 7 are there.
And after that, one got arrested.
One has been arrested and therefore this BA was filed, Lordship. 1 and Mizanur Rahman. Mizanur Rahman is, Lordship, 7. 1 and 7 were arrested. And therefore, for them, this BA was filed, Lordship. In the anticipatory 1 and 7, they are the petitioner in BA. That is my submission, Lordship.
Yes.
PPT page number 3, page number 56. My lord.
Has not been published.
My lord.
No, he is asking something. Copy.
Yes. My lord, I have served the copies. Otherwise, I could not file. It will be defective, my lord.
But whom you have served?
My lord, in the before the court, I have served. My lord, before filing, my lord, in the court, some girl, my lord, girl advocate received. My lord, junior of my senior.
Maybe, but I have said we have got. That's what your copy.
Receive করি কেন এটা মই কেনে
ভেৰিফাই কৰি লম
Copy one.
কপি দিছ
এবিট দিছে নে হেৰি দিছে
দুটাতে দিছো in both cases I have served, my lord. How can I file, my lord, without serving the copies, my lord?
Another copy. Okay. Give me another copy.
No, that's fine.
This is
Yeah, yes. Seems similar. Everything is said. My lord, page number 56, my lord, I have informant categorically stated that, my lord, after if they are released on bail, my lord, they will kill the informant because only the informant is left to look after the victims, my lord. And victims are, my lord, fighting with their life, my lord. They are bedridden condition, my lord. And if the accused side, my lord, is grievously hurt, my lord, how they can, my lord, file the bail and they need anticipatory bail. My lord, the victims, my lord, is not in a position to approach before your lordship, and police cannot arrest them, my lord. They are still, my lord, bedridden condition, my lord. My learned friend said, my lord, senior friend said, my lord, they are also injured, grievously hurt, my lord, everything. Your lordships will decide, my lord. My lord, learned PP also submitted, my lord, forwarding report, everything. Because, my lord, bail is totally depend on your lordships. And the civil matter, my lord, there is no any, my lord, judgment. If I found that in civil dispute is a ground for bail, my lord. If there is any grievous injury threatening to life, my lord, intention is there. Normally, my lord, court can, my lord, allow the bail out of civil dispute. Your lordships will decide. I have that much. My
police report definitely has such a individual matter. And I swear in the city, I can swear that they are no longer in under. They are all recovered.
my lord.
Police intentionally arrest them. We have also filed an application to hire us that police is done or done anything to take them to transportation for our. But we have what about because we have we have and my lord, one thing, my lord, my friend is very nicely submitting that the civil dispute cannot keep it right.
Yes, ma'am.
Attack. But if they are the aggressor, they and trespass to our land.
My lord,
and that time we have to give protection. Then
yeah.
there was injuries on both sides. I am submitting both sides. But it is now they are all recovered, my lord. Both sides are recovered. My two persons are in jail, father and son. That's for period bail before you know. And my lord, whole decision will come up this between the family members where this quarrel is taken up.
Maybe, my lord.
And my lord, there are no intention quarrel. They also intended to kill us. Same section case has been registered against 307 is there. Against them. But police is silent against them. And your lordship, there are other independent witnesses your lordship asked for to produce, whether I do not know whether they have produced a statement of witness.
Yes, Sharma, any independent.
Yes. Witnesses, independent witnesses, there are a number of witnesses. They have witnessed the incident, but they have not taken any names. They have seen the incident, but names have not been taken specifically. That's why Lordship, I mentioned the injured person, Azizul Haq. He has mentioned only these names. The others were not mentioned. That is why I had submitted Lordship. So if Lordship wants, because this is an AB Lordship, and two persons that are before your Lordship for the BA, those are definitely there. There's no doubt about it. So if Lordship wants, I can again update the CD. But Lordship, anticipatory bail at this stage will be difficult, Lordship. There will be a law and order situation, Lordship.
No, think of it. They are living very peacefully. Law and situation, they are living very peacefully. They are family members side by side.
Then I'm sorry to say, Lordship, because it's a very difficult situation, Lordship, because these kind of people, if they are family members and they are behaving this way, Lordship, then I have nothing else to say, Lordship.
Other I respect to submit that. They are
Yesterday,
it is the out of because you people are aggressor. That's why I have to give and take my life. There was a Marpit. I have given they came with the sword and to attack them. What to do?
Lordship, in the IO's note, the IO after going through all these things, Lordship, he has stated that this party are not the aggressor, they are the aggressor.
Sure.
And this is not a case of
Exactly.
they have
We are peaceful position.
the IO has stated, Lordship, that it's not a case of right to private defense, as they are claiming. It is not a case of private defense, Lordship.
But accused is in a accused in a peaceful position, but we are in a fair position, my lord.
And
Well, yesterday night, informant called me, my lord. We discussed with me.
Then you have entered.
They are openly threatening if they get bail from this honorable court, my lord, they kill the informant, the elder brother of the victims, all the victims, my lord. Openly, I have also stated, my lord.
Swearing. Be a law.
Openly threatened, my lord.
We have to
Because he is the only person, my lord. He is not injured. He is not injured. He is the only person to look after his brother. Yesterday night I have talked, my lord.
I can give an undertaking.
Your lordships will decide. My lordships will decide.
Take the law in their own hand anymore.
My lordships will decide.
It is decided by the right. We shall not take the law in our hand. And my two persons have already 27 days are behind the bar, one is 7-year postman, and the other one period as well, but I pray your lordship kindly consider and any consumer. We undertake that we will not take violence anymore.
Yes, it is. Yes, it is, but they learn how to body position. If it also had Mr. Bishop, they learn it. And Mr. T shape, they learn it how appearing for
एक का नाम कौन है?
ঠিক আছে
that is an application.
ঠিক বেশি
It is not
possible to এই মানে এটা
70 that independence of the present
তো পুরো
petition accused petition number 1 and 7 got already attested in connection with this case and they are still behind. Further subject that is the fact that there was a land dispute between the parties and for which one quarrel and tussle took place between them. However, the informant side are the aggressor when they entered into the land of the petitioner while they were cultivating the same. Some civil suit is also pending between the parties. But Mr. Biswas further submitted that the both the parties sustained injuries and the petitioner side had also lodged and brought FIR for the same incident. But police is not taking any steps in the case lodged by him. Rather, they are searching for the petitioners to be apprehended in connection with this case. Mr. Biswas also produced some photograph of the victims to show that some of the victims sustained previous injuries on their person. However, he submitted that all the petitioners are still ready and willing to extend their cooperation in further investigation of this case if they are granted with privilege of the next. Mr. Sharma, the learned petitioner, submitted in this regard that there are sufficient intimative materials against the accused petitioner who were involved in the trial. There are several victims who sustained fracture injuries as well as the head injuries due to attack by the petitioners. It is already specified in the forwarding report of the accused petition who were already got arrested in this connection. Mr. Sharma further submitted that from the record and as well as from the report of the IO also, it is seen that the present petitioners are the aggressor who came first and assaulted the victims, causing previous injuries on several persons. Further, he submitted that as per the note of the IO, there may be law and order situation even as the petitioners are still threatening the informant. Accordingly, he submitted that it may not be a fit case to extend the privilege of pre-arrest pay to the present petition. However, he fairly submitted that the implications are especially against the petitioner number 1 to 7, out of which 1 and 7 are already got arrested. However, there is no specific mention about the other petitioners, that is the petitioner number 8, 9, 10, and 11. 10, 9, 11, 12, and 13 in the statement made by the witnesses. So they have uttered that the others are also engaged in assaulting the petitioners, the informant. Informant. Next one. Mr. Sheikh did not counsel appearing for the informant submitted in this regard that the the informant is the only person to look after all the victims, as they are still in a bedridden condition who sustain fracture injuries as well as the head injuries on their person. And there is every probability of um, uh, committing similar kind of offense if they're granted with the privilege of re-arrest bail. If further submitted that as per the instructions of the informant, the petitioners are still threatening the informant side with dire consequences if they get the order of the next. During the submission made by the of both sides, I was built case report and the annexures along with the petition and the case diary. Considering the matrix in the case diary, it is seen that the several victims sustained previous injuries on their persons, with fracture injuries as well as the head injuries. From the statement made by the witnesses as well as the victim, it is seen that there was also an attempt to kill some of the victims during the incident. So considering the materials in the case diary, this court is of opinion that case petition number 2, 3, 4, 5, and 6 are not entitled for privilege of re-arrest bail at this stage. However, the petitions number 8, 9, 10, 11, 12, and 13 may be granted with the privilege of re-arrest bail with so and so and so. So, thus prayer for re-arrest bail for the petitioner number 2, 3, 4, 5, 6 is hereby rejected, allowing the expenses. Your 8, 9, 10, 11, 12, and 13 are granted with pre-arrest bail, and pre-arrest bail prayer for 2, 3, 4, 5, and 6. 1 and 7 got already arrested.
No,
Yes. So 2, 3, 4, 5, and 6 are rejected. The rest we have granted them.
But 9 and 10, they are the government.
9 and 10, 9 and 10 we have already granted. 9, 10, 11, 12, and 13.
5 is there.
Sorry,
But
8, 9,
he was
10.
before, my friend.
Who? Who?
No, Lordship. 5, petition number 5. He was present, Lordship.
Yes, present.
Is the meaning?
Now to what
One of the-
two advocates are involved, what to say?
I'm sorry to say, Lordship.
There are many cases wherein the advocates are found involved in
But he is main powerful man, man.
Yes,
Lordship, the BA also, Lordship, needs to be
not
disclosed.
only powerful, he is an advocate also.
Yes, my lord.
He
He
know the,
misused the name
know
of
the law.
advocate.
Vision is a very powerful.
Misuse.
He know the law.
But he was not a present here.
All present there. The
He
video.
was very much
he is
present there. He was very much present.
Lordship,
But
BA,
That's why Mr. Sharma, though I have not categorically gone through, but it is submitted that they are the persons 1 to 7 who particularly involved in this case. That's and the pakikni ability ba hard so and so going to apply to duta petitioner say BA to BA বাকি এইটোৰ লগত মিলাই পেলাই লিখি দিব dismiss কৰা হৈছে BA is dismissed.
Lordship.
Father and son.
Father and son is dismissed. They are the main. They are the main.
They are the main persons.
They are the,
Highly obliged.
They are
Also proceed.
granted bail.
no,
No.
they have not granted bail at this stage. Their prayer is rejected. Pardon?
BA.
BA is rejected. Rejected at this stage. Same মিলাই
Rashid submitted, Lordship.
chances.
I am on the engine there.
You have cooperated in the
My experiment is on there.
Yes, yes, number for the yes.
57/26 dated 28/4/26.
24.
28/4/26.
Give a accent to input so that you can verify. We have already, if you have already cooperated or accepted the no, no.
We have received the case there.
Yes, sir. Your petitioner number, you are two. You are two. Yes. You are two. Yes. So who is the petitioner? Accused number two is the petitioner. You are moving.
Your Lordship, he has appeared in a statement record also. The agreement was made executed between the complainant and another person, Zaharul Islam. For,
Number one.
yes, for purchasing a vehicle, Lordship, Alto K10. And as per the agreement, he has to pay the installments, 55 installments, as per 9528, was 9,520. And later on, the infant found that the vehicle was sold later on to another person. Here, the petitioner was along with him, as per the statement of the second party, Zaharul Islam, who purchased the vehicle, Lordship. The vehicle was with him at present, but that petitioner simply denied it. No, I was there, but vehicle was not with me. I have a business on car selling business with but I have not I was not in my position in the vehicle. That is the
Basically,
because
number one.
yes, informant. As per the statement of the
Selling the vehicle, is there any information of this?
as per the statement of the purchaser, he has the vehicle was with him in the petitioner, with the petitioner. That is the that's why he was before us, Lordship, but he simply denied it. I was with him when the agreement was executed. That vehicle was not with me at this present. He has appeared on statement record.
What the position of accused number one for arrested?
No, he was not arrested, Lordship.
Accused number one.
Yes. He was arrested, yes, yes. He said, as far as his statement, the petitioner's name, Lordship. Because when the agreement was executed, Lordship, this petitioner was present with him, Lordship.
One thing is there, FIR was
But vehicle was not recovered yet as per that.
Which forum you will appear? Which forum you will? You want to suggest him to appear in which forum? Which forum you will? In all the your vehicle, if we could be recovered, so in which forum you will appear? Is there any forum for the informed to appear? Seeking custody? If custody vehicle is not there, from whom custody will stop? Is there any where from he will stop for the custody?
Yes, can go. So here, what has happened, Lordship, the trial has already started. He has been issued summons and it is fixed for appearance. He has filed this AB, Lordship. Lordship, I'm failing to understand how is it maintainable, Lordship. No, it's not about power. He has to justify, Lordship, that why he is apprehending a day.
No, no, apprehension, let's forget about your apprehension. How the case is there? That's what he is asking.
Maybe right. He was behind the bar. He was ready. That problem is that my lord, long back to 14 minutes. But at that time, because
evidence.
No. Appearance.
they are not committed even. My apprehension is that matter. My initial matter, I was arrested my lord. Ultimately, the Landed Court granted me bail my lord. I even submitted bail bond my lord. Presently, my lord, nothing is available in the record my lord. So my lord, bifurcation of the new my lord, it is new.
You are submitting that.
Yes, my lord. Yes, my lord. Remember.
Now what is there?
Yes, Lordship, he has.
My Landed Court will still category to come before me with an approved order. Otherwise, I will put you behind the bar. This is my problem. I have to nothing left to go anywhere.
Cannot be, Lordship.
The other orders we have. The other
They have annexed it here, Lordship. The court has only issued summons, Lordship. He has to appear and file a bail application. So what is the harm in that, Lordship? Why is he anticipating, Lordship, that he will be arrested? He has to justify that, Lordship. The court has not issued any bailable warrant or non-bailable warrant. The court has issued summons. He may also be granted bail, Lordship. So how can he submit, Lordship, that I will be arrested? He has to justify that, Lordship.
We can we have to take care.
we can go there. But now your case is a bit different because you were arrested, you got bail.
Yes.
Yes.
That is everything is there.
Yes.
In that case,
Yes.
there cannot be any such apprehension.
Okay. In the record, my lord.
Why don't you file a application before the Administrative Court below? That is the position. So why don't you call the record from the concerned that is there?
Not available.
They've annexed the order, Lordship.
Not available.
They've annexed the order, Lordship. Annexure 3 order dated 29/11/2004. The Lordship will kindly see Annexure 3, page 20. Yes,
Last time, till 11, 12, 13, 14. It's already. For my lord.
Let's forget about it. Now you are shown as an absconder. No,
Oh my lord.
not shown as an absconder.
Yes, ma'am.
apprehension has to be there because anticipatory bail, the basic foundation is the apprehension.
Yeah.
He cannot state lordship that I will be put behind bars. He may also be allowed to go on bail. Lordship.
He will.
Yes.
Because you are not shown as an absconder.
Yes.
Bail bond order, acceptance of the bail bond order is also with you.
Yes.
So what is
Yes.
Not with me.
no, the order you have annexed?
Correct. That order is available in the record.
Ah, yeah.
Then
When my because
this is lordship. This is like putting a question mark on the trial court. Lordship. This is like putting a question mark on the trial court unofficial. How can he submit lordship something unofficial lordship?
No.
No, this type of submission.
Administrative court finds some difficulty, but if you are shown as an absconder, suppose then
Yes.
there are some difficulties.
Maybe.
You are on bail.
yes, ma'am.
Yes.
Difficult.
Well, lordship. So
That is interim bail, ma'am. What? Is my problem. When my lord, that is go by he didn't sign my lord anything, my lord. Yes, I will.
for that purpose, then lordship, I will have to go to the records. We will have to see the prima facie case against him. Everything will have to be seen, lordship. It is not a case, lordship, that anticipate because the charge sheet has been laid. He can file anticipatory bail. There is no question, lordship. But that has to be based on certain things, lordship. Lordship will have to see that whether he is entitled to anticipatory bail or not. And for that purpose, I will have to go to the record. No, I'm sure that is not the criteria for anticipatory bail. I will go. Simply, lordship, because the case is such, I will file my anticipatory bail and the court will grant me anticipatory bail. Is that the procedure, lordship? That cannot be the procedure. Lordship. So, lordship will fix a date, then lordship, I'll go to the record whether he is entitled for anticipatory bail or not. Yes. Yes. Yes.
Appeared for
Yes. Yes.
you have appeared. Because interim bail has closed.
Yes.
And his
Yes, I have seen. Yes, lordship. That is why I am
bail-
submitting, lordship.
bail- yeah. Except the absolute order is not.
Yes. Wait.
Obtain any absolute order.
That is the case. Lordship, he can also produce this order before the court, lordship. Then it will be the duty of the court, lordship, to find out.
He got arrested.
Yes, ma'am.
He got arrested. But he got bail was granted in prison.
Lordship.
The bail was
Yeah.
is with
Yes. Yes.
the
I will check the
you
record.
got to
I will-
appear in trial. Oh, whether they appear true, the record, whether they executive or
I will go through it. I'll go through. Next week,
21.
already voted.
In that case, 20. 25. What is the next date? 22. 22. Or 20 is 25.
Yeah. I received the case there. I have given it up.
Yes. Is that way? You have already come. You are Papi. Both Papi and Bablu.
Papi second, Bablu second.
Mr. Mangal. You, Mr. Mangal. There will be some conditions. adjourn. Interim is okay. If you are seeking adjournment, where is the position?
Report is, we have received a report.
Report.
The report was called for after the entry was, DD entry was done, a case is registered or not. A preliminary inquiry was done, therefore order in revealed that no case is registered against it. A civil dispute is going on, that's why no case is registered against the
So no case is there. Anyways, you may not be in a way. Well, 20. Is come to court. They were on interim. When we were on interim. One zero nine is 103 is added. So it when we were on interim.
Yes.
There was no interim for one.
Yes.
Added second one. Yeah. What is your submission?
Okay. Petition number 2 and 3 are interim. The interim was granted as per the submission at paragraph number 7, where they have stated that the petitioner number 2 is the wife of petitioner number 1, and petitioner number 3 is the daughter-in-law of petitioner number 1 and 2. The petitioner never involved in this fight, and they have tried to stop the fight, which was taken place unfortunately amongst all family members. Because they were not involved, that submission was made and interim was granted because they are women. Now, Lordship, the victim who has died, Abdul Rashid, Lordship, the post-mortem report is here. I will not go into the number of injuries, Lordship. The opinion is death was due to coma as a result of injuries sustained over the head as described. He was dead, Lordship. There are statements of Lordship, some eyewitnesses, three numbers, Lordship. They are the neighbors. All of them have stated, Lordship, that these two women, they were holding the person for the others to hit, Lordship. This is the categorical statement, very clear, Lordship. I will just place this statement. And all these accused person, Lordship, the item number 6, they are already behind bars, Lordship. They have been named, as well as the petitioner number 1, 2, and 3. Lordship will kindly go to the eyewitness statement. 3 in number. Here, Lordship, Sajina Begum and Sabia Khatun. They have been specifically named as holding. The only witnesses stated the same fact.
Fair woman.
Yes. Now, Lordship will kindly take up the affidavit filed by the respondent number 2. There are 3 witnesses. Lordship is in. These are only the eyewitnesses. I am not going to the other witness. Now, Lordship will take up the affidavit filed by the
Of informant. Page
page
39.
Page 39, Lordship.
In
I'm yes, in the AB. I'm sorry for showing this photograph.
39.
39, 38 and 39. Lordship. 39. I'm extremely sorry. This is the photograph of the head. And Lordship, page 48, they have preferred one. Yes. Now, Lordship will kindly come to page 48. They are facing threat, Lordship, even now. And they have preferred one complaint before the SP of police, Lordship. So, Lordship, these are very dangerous people, Lordship. That is my respect for them.
He had already submitted.
Yes, my lord, I will, my lord, death certificate also shows that death caused due to head injury, my lord. Further, the photographs shows that death was caused direct assault due to the assault. Death was caused, my lord, and 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 the informant are getting hurt, my lord. And they still now, and this regard, they have approached before the SP, my lord, and they have filed an application before the SP, my lord. So my humble suggestion, if the accused person
land is or land, they could. Yes.
And putting the now to go through the লগতে আব্দুদ্দিন আব্দুর রশিদ মুহিবুল হক কীর্তন নেতা already have
Improvement
something.
goal for- on the case.
What I'm the order there there also uh, there also something around 10 members in total and the fact of it, they can
It's a matter of these are assumptions, Miller. It's
and we have gone with affair. That part actually
that affair was not enclosed with the bail application, Miller.
Even if FIR is filed, Lordship, one person has died, Lordship. So it won't help them.
here also okay. And in the
How many days they are behind the bar? How many days they are?
I do not know. One, one,
81 days.
one.
Number one. It's in there because what you
Lordship, it can be rejected at this stage, Lordship, because the investigation is still going on, Lordship. Some persons
if
are
the
yet to be arrested.
investigation is still going, can it be expected that within
Maybe, Lordship, even part suspect can be given, Lordship. I'm not sure. But it will going into the heinousness of the offense, Lordship, may not be considered the length of the
Now, movement and more. So, what another factor, the repetitive activity of citizens have a
Number. Okay, we're rejecting. But it can be.
From Bilasipara, Hubli.
One is 50.
Recorded in advocate in the struck off. For the in the whole
CD not received, my lord. Twentieth, my lord. Mistake. My lord, no, my lord. CD not received, my lord. Yes.
They are not only
Not in India. Then, my lord, short date, my lord. 21st, my lord. 22nd. 22nd November. Piছত তেতিয়া দেন 25, 26. 26.
Initially, and there are there. And then how when it there are with regard to the FI to inform you that the appropriate for the first I like other
in cash and cash presently voted for this. I was and my deputy is already arrested. Yeah, number one is the and number one and my father. There's no way connection. I know my take of the forest. That's okay. The fourth one. Chapter page 22 onward. This is MS Webinar Prana, page 38,000. Then in 19,000, both of page terminology. Then Delhi has been staying now.
23%.
It's a matter of 1 year, 1 month, or 10. And he has taken loan, and that is technical. But he has returned till get the principal, but only this. And so this is an FIS loan. The whole transaction might be then the page 31, page 31, Sadhana Ahmed Tabuktar, 3,800. Whatever she gets, whenever she gets, page 31, all transactions are to the same thing. Right? To be informed. So my logic that they are the local residents, they have no such existence of relationship. And she has paid it. But still with regard to the interest. So initially they informed me that they were paid it. So there arose some dispute and then this affair. And brother was already arrested, who has no connection with it. And even but and none of us connected with it. This lady I love it and the election is what
My lord, here, my lord, there is this transaction amount is my lord 12 plus 90,000, my lord. In case of my lord, the petitioner number one, who is my lord, that is the FIR name accused number one. Admittedly, my lord, petitioner number two is not FIR name. In this regard, my lord may grant interim to petitioner number two, or in the meantime, city may be called for. But my lord, transaction is there, and my lord, that accusation against the petitioner number one is there. I leave it to your lord.
It's but
My lord, 3rd of June, my lord. I have
Yeah.
Let it be at the admission column, but in on a hearing day, if your lordship is used to fix that, perhaps it can be disposed of at the admission stage.
I take that. Fourth of June is the hearing.
And-
Second.
Anything after 4th of June. পুরোটা একটু হবো। 18th June. 1. All right. All right.
Application step. Conviction. Against acquittal. There is no counsel for the respondent raised no objection at the time of allowing. hearing date 16th of. Yeah, we did. Yes.
Yes.
You are directed.
Yes. Yeah.
Till now, by obliged to court order, you have
On that day, madam, yeah. So, there is yeah, madam. There is no stay, madam. Press the yeah,
otherwise the case was ready for voting and for day of the NBW. You are 12.
12.
Now you under the same.
Yes. Here, my lord, that is my lord, on 23, 2026, this honorable court was pleased to my lord, direct kept in abeyance my lord, with the NPW order. So the order sheet reflects that 26 to 2026, my lord, the accused Samim Ahmed is present in the petition number 7 filed by the counsel for the Sawel Ahmed Tarukdar, stating that due to his sudden illness, he could not appear today, which he was supposed to do as per criminal, and that order reflects. And next it has my learned friend has submitted a 9 for 2026 matter that is submitted. But here record is up to date up to matter 10 2026. And the next prayer already he has submitted, my lord, that my lord, regarding my lord, the quashing of the proceedings, my lord, NDPS commercial quantity. He would like to withdraw the petition. Only he is praying for that, my lord, he can appear in the trial, my lord. So my lord, that order is not available, but the earlier order is there. I have flagged marked that. So I leave it to your lordship.
Thank you.
My lord, horizontal flag. One horizontal flag I have flag mark, my lord, that particular order. Yes, horizontal flag. The order sheet. Horizontal, my lord. Two horizontal flag marks are there, my lord. One is there, my lord, for the order sheet. Ready to the order to like.
Yes.
26 to 2026 or
Indeed.
Only my one prayer is there. Condition may be there in the next that he must appear, my lord, before the learned trial. And if, in absence of that, my lord, the trial court may issue, my lord, take their, my lord, course. If not, that condition.
This were evident. So you want to take precedence. What is it? 4 years.
Yes.
Thanks for hearing my.
My lord, objection is because my lord below 10 years and 10 years. Yeah. My lord, here, please, my lord, if my learned friend, my lord, submit, then my lord, we will just, because my lord, only the case is that victim is a my lord class 6 student. That it is a class 6 student. Only that part. Otherwise, my lord, only just I have my lord tag mark the PW1, leave it to your lordship. Just my lord may kindly produce the depositions of PW1 along with the 164. That part of. Otherwise, not aggravated matter is there, matter.
Accordingly listed on 1, oh, sorry, 20. 20. We'll try to hear the matter 20. That's what I'm saying. We are fine. In directed you are going to furnish with it during the course of the day. Notice was served. 30th April. Report is obviously you have submitted these documents, but it has to be make an inquiry by the registry. Nick code, you have received this one from the postal. Huh? Who collected this one in the last page? By the registry or by you who furnished it? By the registry. Huh? Submitted by you only before registry. But there is no note in the registry. No, with the section, concern section, but there is no note at all. Will ask the registry to make an inquiry in that regard, otherwise. AK protester ilane super petition. Not to participate. A posture ilane petition 50 everyone. As per office note dated 2 dated 2/5/2026, service report is still awaited for the response number. State is response number 1 or 2?
Two.
You are 2.
Yes. Respondent number 2.
Respondent number 2 हो जाएगा awaited for respondent number 1. But it is submitted by Mr. Professor that they have already received the they have already received the track consignment report, wherefrom it is seen that the consignment was delivered already to the respondent number 1 on 30/04/2026. A copy of acknowledgement is also hereby furnished along with the copy of the track consignment report is also furnished before the court. In view of this, the registry is hereby directed to make an inquiry in regards to the consignment report, which has already been submitted by the learned counsel for the petitioner, and to report the court accordingly in the next date. 5th of June. 5th of June. After appearance. If some report is there from the registry, that obviously it was delivered, then in absence, we can hear you. You want this one to be you to return back you, or okay, we'll keep in the record. We have not visited to Arunachal now. Acha. Pardon? Still now, but as I am now in the principal seat, so now not frequently, but yes, obviously we are going. I love to work there in Arunachal. It's good. Environment is also good. Peaceful environment and the yes.